All right, we're going to cover chapter 14 now, and it is a chapter that deals with pretrial motions, discovery motions, and primarily, and other kinds of motions that are typically filed before a trial begins. I want to tell you also that we are going to announce somewhere within this video the due date of the project, um, the book report project. So this is your incentive to listen to the end. I don't know that everybody's listening to these videos. I trust that in due time everyone will. All right, so um, the first thing to cover in discovery, or rather in pretrial motions, is that there is a federal rule, Rule 12A and 12B, and there are counterparts in state courts um, that basically talk about the process of once an indictment is returned, what sort of litigation transpires after that. With respect to 12A, it talks about the sort of pleas that can be entered. Um, and in Alabama, there are uh, pleas of not guilty, not guilty by reason of mental disease or defect, and then um, um, guilty, generally in a negotiated guilty plea. Um, in other states, there are no contest pleas or what are called nolo contendere pleas that basically say, I believe that the state can prove its case, but I'm not admitting guilt, but I also don't want to risk trial. Alabama doesn't have a nolo contendere plea. There is something called the Alford plea, ALFORD, the Alford plea, um, that basically is kind of the same thing, that says, where the defendant will say, um, I'm not admitting guilt, but I'm admitting that the state could prove its prima facie case, or could prove um, the elements of the offense such that it is in my best interest to plead guilty. Um, so the offered plea is sometimes called the best interest plea. All right, so Rule 12A also says that a lot of the formal um, common law pleading techniques of demurrers and all those pleas and motions that were, highly technical and a trap for the unwary, those are abolished, and basically what is left are just simply raising objections in plain language, seeking a dismissal or some other remedy, um, rather than the common law pleading that was very complicated and much like what was in the civil procedure pre-federal rules of civil procedure. Um, and of course, there was all kind of variation and state to state oddities. But just like the federal rules of civil procedure, the federal rules of criminal procedure have led into an era of standardization whereby the states have developed rules that mirror much of the federal rules as if they were guidelines. And this is also true of the federal rules of evidence um, that are numbered the 100s, 200s, 300s, 400s, on up to the 1000s. Um, and so Alabama has a set of evidence rules that are have similar numbering, very very similar, but have some important distinctions that have to be understood as you move from federal rules to state court rules and how they differ in certain aspects. Those happen to have been adopted in Alabama somewhere around 93, 94 when I first began practicing. And I had the good fortune of having a professor at Alabama, Charles Gamble, who was the primary person involved in adopting the Alabama rules of evidence. So it was a good time to be going through to get that sort of firsthand education about the evidence rules. Okay, so the 12B deals with rules that must be, or rather motions that must be raised before trial. Some motions have to be raised within certain time after the arraignment, such as motions to sever, we'll talk about in a minute, or certain challenges to defects in the indictment. Then there are other motions that just have to be raised sometime before trial, such as on page 270, motions to suppress evidence, requests for discovery. Those are things that are not limited in terms of a certain number of days after the indictment. There are other notices that have to be filed, certain notices of affirmative defenses, most likely or most commonly alibi defenses, that is, a defense where you can prove that you were incapable of having committed the offense. Not that there's some murky factual dispute, but that there is a set of facts that you believe you can prove that will show that you were not in a place or at a time when the crime was committed. Those must be disclosed in order to allow the prosecution to have the opportunity to vet the allegations about your not being in a position to commit the crime. And the insanity defense, of course, must be raised pre-trial. A self-defense defense, if you want to avail yourself of the stand your ground hearing or the immunity hearing, that of course must be done pre-trial and should be done very early in the prosecution, because as we studied weeks ago, that a successfully tried and granted motion to dismiss based on the stand your ground law will end the prosecution. It's not like a situation where the judge, maybe it gets dismissed, maybe it doesn't. If the proper showing is made by the preponderance of the evidence that you are acting in self-defense, then you're able to get the case dismissed very early in the process. So that's another common pretrial motion that's raised before trial and ought to be raised as early as possible because it allows the charge to be dismissed early on. One thing that I think is important to understand, that there are very, very limited ways to get an indictment dismissed over factual issues. And if you've studied civil procedure, you know that there is a mechanism called summary judgment, Rule 56. Summary judgment allows the defense typically to test the strength of the plaintiff's case. And if you can't produce substantial evidence of your claims, then the case doesn't proceed to trial. In other words, if you're doomed to lose your case, we're going to find that out in a pretrial setting that allows both the state and the defense to escape the expense of trial, of preparation and trial, and conserves judicial resources. There is not a similar mechanism in the rules of criminal procedure. So, I've had cases where clients tell me, I don't understand why we can't get this dismissed because there's some weakness in the case that's pretty glaring. If you can get the DA to see it, maybe they dismiss it. But if you cannot, then the criminal case has to be tried till at least the point that the state rests its case, and then we'll talk about this in the next chapter. The defense can move for judgment of acquittal, citing an insufficiency of proof by the state. But there's no way to do that pre-trial unless there is a way to frame it as a motion to dismiss as a matter of law, which is saying we don't have a dispute about the facts. Believe what the state says. It doesn't constitute a crime, or it doesn't constitute the crime that is charged. And so it allows the defendant in those rare cases where, as a matter of law, the facts as pled and as discovery may have shown you to exist, just simply don't constitute a crime. A common example of how I've dealt with that is in disorderly conduct cases and in resisting arrest cases, where those are often paired together, where the disorderly conduct that was alleged just simply was not a crime because of the First Amendment, like using the F word, flipping off a cop, things that are not a good idea, but nonetheless are protected by the First Amendment. You can raise that in a pretrial motion and say, Judge, this ought to be thrown out before trial. But what you're doing is saying, believe what the state says. If my client said whatever, it just simply doesn't constitute a crime, and we shouldn't be forced to go to trial in order to simply have the court decide that once a jury's impaneled and we've had testimony for a day or two. Okay, so if you're dealing at some point with a client that says, why can't we just get this dismissed? Just reassure them that there is no reliable way to do that when the facts appear to be lopsided. If the DA is going to take a lopsided case to trial, so be it, but you can't get it dismissed until the state rests, subject to the few things I've talked about as exceptions to that. Okay, so next we'll move into discovery. So discovery, as the book will describe, is a relatively new innovation in criminal jurisprudence. Until about the 1940s, there was no real discovery, but it has, as the rules of discovery in civil cases grew more and more liberalized, it was less and less defensible in the weightier matters of criminal law to deny defendants right to discover things in the possession of the state. It supports the presumption of innocence as well. But what had happened before then is just, essentially what we call trial by ambush. You went to trial with some idea what the state might have. There would be obvious witnesses that you would know to interview, but there would also be witnesses you wouldn't know about. There was a lot less expertise in terms of forensic evidence, and so there would be more sort of lay witnesses and less specialized knowledge, therefore fewer reports to that the state might have that should have been disclosed but weren't, whatever. There's just no obligation to turn over evidence. But one of the things that happened with this Wardius, Wardius, I believe, case was the court said essentially, if we're going to require a defendant to give advance notice of an alibi, that is, tell the government that they're going to use an alibi defense, and here are the basic facts, give them the opportunity to investigate the defense, then there ought to be some concomitant obligation of the state to disclose things about their case. In other words, discovery had to be a two-way street. And so another force that drove the modern approach to discovery is the use of plea bargaining in criminal cases. Plea bargains were much rarer in the time before discovery because, if the DA didn't volunteer information, you might not know that they had a solid case, and so cases went to trial more commonly. So if the system is going to have primarily cases resolved by plea agreement, you have to. There's a sort of a common sense requirement on the prosecution to explain and demonstrate to the defense why they should take the plea. The liberalizing of civil procedure discovery and the growing dependence on negotiated pleas as a means of resolving cases required that the state disclose things about their case ahead of time. And of course, the Wardius case and that development where the Supreme Court recognized that it was unfair to require a notice of an alibi and its circumstances to the state, and then the state have no obligation to make any disclosures to the defense. Okay, so discovery is controlled by Rule 16 in the Rules of Federal Criminal Procedure. Alabama is Rule 16 also in their criminal procedure rules. And it provides discovery of certain limited things, most notably the statements, written statements, recorded, videoed statements, or just simply oral statements that the state intends to rely on, certainly, and any oral statements made by. They don't have to necessarily be, something that was said that indicates that your client is guilty. It may well be something they said that indicates that they're innocent. But any statements of the defendant, oral, written, video, otherwise, and co-defendants, any person that's charged along with them. Then the next thing that must be disclosed is the defendant's prior criminal history. And then the third thing is scientific reports, just following the rule, the numbering of the rule. The third item is documents and tangible things that the prosecution intends to use at trial. And by documents, we obviously mean paper, video, audio, those kinds of things, and tangible objects, tangible evidence, a murder weapon, um, that sort of thing, that's other than a documentary recording, but is nonetheless something that can be held and touched and examined. Those items have to be disclosed ahead of time. And then finally, scientific reports such as autopsies, the work of the Department of Alabama Forensic Science, the Alabama Department of Forensic Science. Shorthand for that is DFS, and that may be drug tests, testing of substances suspected to be controlled substances, firearms, ballistics, fingerprints, DNA, what are called tool mark examinations. That generally rounds it out, but those scientists, technicians, physicians, they generally generate reports, and those have to be shared with the defense. So that is what the rules require. Some states require witness lists. Alabama doesn't do that. The other thing that the book talks about that's not a rule, but well, the federal rule is codified in the Jencks, JENCKS Act. The Jencks Act allows discovery of witness statements, but only after that witness has testified at trial. So when you see that, and what the book doesn't tell you is left out of ordinary discovery, are witness statements. And that's incredibly unfair, in my view, that you're not entitled to witness statements to document that what the government says it can prove, that it can prove via witnesses. Now, what often happens in cases is you might have the witness statements given to you as a means of saying, look, we've got a case that you don't want to take to trial. And, you know, if you're known as somebody who will take a case to trial, and you're not just looking frantically for a plea offer, but, you know, the prosecutors know that those kind of lawyers, you know, if your goose is cooked, if my client's goose is cooked, show me. In other words, show me those witness statements. And then perhaps the case would settle. But I'm not going to take it on faith that these witnesses say X, Y, and Z. So it's really strange to learn that you don't get witness statements. You get your client's statement, you get your co-defendant's statement. You don't get witness statements as a matter of course pre-trial. The Jencks Act and Alabama case law now says that you can examine witnesses' prior statements after they testify and before your cross-examination begins. Now, the exception to this typically comes in capital cases where you have what we refer to in Alabama as an open file discovery orders. Those are routinely granted such that everything except work product must be turned over to the defense. That is witness statements, and it involves scientific tests, and beyond that, the resumes, CVs of the quality control that is behind some of those tests. It goes deeper than the ordinary, like, simply here's the report. So, interviews that with witnesses that didn't materialize, leads that didn't materialize, you get that kind of disclosure in capital cases under the open file discovery rule. The idea is that death penalty cases, that death is different. It can't be adjusted. And so we had better be sure to not stack up false convictions because we haven't allowed attorneys to learn everything about the case. Again, open file discovery often drives settlements of capital cases. Death cases are sometimes settled for a life without parole. And that's not extremely common, but it happens. And capital murder cases tend to get settled for life sentences in appropriate circumstances. Sometimes, they'll settle for some term of years rather than simply a life sentence, a 30-year sentence, 40-year sentence, or whatever. We'll talk about that in the next chapter that deals with plea bargaining. But certainly in capital cases, a plea is not very casually entered into. And so without the open file discovery, you're going to be dealing with a client that says, well, what about this? Or what if this or the other? You've got to have access to all the evidence that the state has in order to conduct your own investigation more efficiently and properly, and hopefully drive settlement of cases where the stakes are so high. And in cases where settlements just aren't going to happen, perhaps it allows you to prepare a defense that will prevail and innocent people are vindicated in those cases that have such dire consequences for anybody that are found guilty. And those are the worst of the false convictions where someone's on death row or has been sentenced to life without parole. And so those cases are treated differently. In reality, all criminal cases ought to be open file discovery. There shouldn't be any surprise or ambush at a criminal trial. It's just seems to me to be violative of due process and doesn't serve the ends of justice effectively, and can lead to false convictions. Just because the less prepared a lawyer is, the less prepared they are to discover that a case is perhaps fatally flawed in some way that's not apparent from what you would simply get in Rule 16 discovery. All right, we're going to chop this up into 2 or 3 installments. We're going to stop here and start with the constitutional discovery next.